Good afternoon, Kaminsky Law. Today we're going to talk about the difference between small claims court, arbitration, and the Court of Common Pleas in Pennsylvania. We get tons of calls from people saying, I am out money. What can I do? The first question we typically ask is, how much money? Why do we ask? Are we curious? Do we want to know? Does it make a difference? Well, yes, it does make a difference. If you're arguing over $12,500 or less, you belong in small claims court. Small claims court is a local court that you can look up online depending on the county that you're in. Each county in Pennsylvania will typically have multiple small claims courts where you can file your own complaint. You don't necessarily need to be represented by an attorney, and you could show up and you could plead your case. Most people compare this to Judge Judy or the People's Court. You basically come in on one day, you have all your evidence there, you plead your case to the judge. The judge hears your side, they hear the other side, and then makes a determination. Some people want to have an attorney for that, but more often than not, you don't need an attorney to go to small claims court. The next level of court is arbitration. That is everything over $12,500, but under $50,000. That subjects cases to mandatory arbitration in Pennsylvania. So if you're suing over $20 or $30 or $45,000, you will follow the same process of filing a case as you would in the Court of Common Pleas, but it will be streamlined. There will be streamlined discovery. There's going to be streamlined process. And the point of that is to keep your costs low because the matter is going to be arbitrated rather than litigated full on in front of a jury, etc. The next level of court in Pennsylvania is the Court of Common Pleas. Now, there's the Philadelphia Court of Common Pleas, Bucks County, Montgomery County, etc. Each county has its own Court of Common Pleas. Those courts typically hear either an appeal from a small claims court or an arbitration, or a case that involves more than $50,000. If you're going to file a case that involves more than $50,000, it will get filed in the Court of Common Pleas. There, you will be subjected to the entire legal process, which can get expensive and cost in the tens of thousands of dollars, which is why we try to make that distinction early and to understand how we can help. So, before you call a lawyer, think about what your damages are. If your damages are under $12,000, you might be better off just going on your own. And we're happy to help you or give you some advice, but using a lawyer in that case isn't economically reasonable. Whereas if you have a case that's somewhere in the $20,000 to $50,000 range, you could try to streamline the process in an arbitration, and we'll certainly help you do that. If you have a case that involves more than $50,000, or you're asking for what's called equitable relief, which is you're asking the court to compel an order to something or make somebody do something, you typically have to go to the Court of Common Pleas, and that will be a longer and a more expensive process. As always, we're happy to help at Kaminsky Law. Consultations are always free. 215-876-0800.